There is considerable material to cover, and I've got news for you. We're not going to be able to cover it in an hour and 15 minutes. I think that's what I have here. My name is Stephanie Miller, staff attorney, California Appellate Project. I'm accompanied today by Paul DeQuattro, who wisely, fortunately, he doesn't have to stand in front of the screen. I like to make him do it, but he's not going to do it. I don't blame him. But anyways, so knowing that we have to go through, we have to shift into fifth gear in the portions in the speed of life that we're in here. I prepared a two-page sheet of what I call talking heads. And Bob, if you'd like to hand them out to people, here they are. Just for so that there's some ability to take notes, even if you don't, get everything or you can't take notes. You'll at least have this sheet, these two sheets of paper that identify, well, we said something about that area, so, and then hopefully that'll generate discussion as to what was said about that area. What you do have today in far more depth is a summary of published case law. Okay, summary of published case law that was filed between the period of June to October of this year. Now, amazingly, and these are just summaries, obviously they're not the entire opinion, but this is 36 pages. So just in less than maybe 3.5 months, we've got all of this law to deal with, which is a daunting prospect, and just gives you an idea of what our responsibilities are as lawyers. I always like to, by the way, I should, Bob, make sure you give me a copy of the talking points, because otherwise I'm not going to remember what the heck, no, I'll forget. I'll talk about everything else but what I was going to talk about. So, first off, we have the same client, usually. Of course, California Appellate Project appoints attorneys not only to represent the parents, who you are appointed to represent, but also de facto parents, sometimes aunts and uncles, children. But we're going to talk about representation of parents here. And in that sense, having that client in mind, CAP-LA and Ladle share the same client. Therefore, it's important that we work together to best represent that client. I am going to speak briefly about effective representation of counsel by trial counsel, and I don't want this to come across at all as in a fearful manner, to strike fear into your hearts. I want to present it as the way I truly believe it should be presented, as a cooperative effort. Fortunately, fortunately in dependency law, we have the wonderful mechanism of the 388 petition. And the 388 petition is a wonderful mechanism because it allows us to correct mistakes. So a first option that I'm always looking at when there's a question about, gee, boy, gosh, should that have been done by trial counsel, is, okay, look, can we just deal with this by a petition for modification of orders? I will return in a few minutes to the matter of our effectiveness as lawyers, both as appellate attorneys and as trial lawyers. I'm going to begin with some basics, okay? Now I'm going to be referring to the talking heads sheet, okay? Because I think there's a group, right, talking heads, and I don't want to say talking points, so I hate that. It's so talking points, and it sounds so intellectual, and I'm really not an intellectual. So I'm going to our talking points or our points of discussion. No, we're going to stick with talking heads and try to keep things light. So, look, one of the very first things that you have to do when you walk into the courtroom is to identify the judicial beast before whom you are appearing. Right? Who the heck is this? Okay? Is it a judge? Okay, is it a commissioner? Is it a referee? What does that plaque in front of the bench state? And really, most probably, you can't go by what that plaque states. Because most often you walk into the courtroom, and if there's a commissioner, a bench officer who holds an appointment as a commissioner, they're certainly not going to sit there with the lowlier referee plaque. Heck no, they're going to point out, you know, have plastered there, commissioner. Well, does a commissioner have authority to conduct proceedings under the juvenile court law? Not enough of you know the answer to this question, and I'll tell you what has happened here as a result. Okay, Commissioner Emma Castro, fine lawyer, trial lawyer for many years here in this courthouse, then once a head of one of the ladle firms, then appointed a commissioner of the Superior Court, who went on to many different courtrooms in LA County, and then returned in June of 2013 to this bailiwick at Children's Court. And I thought, gee, okay, Commissioner Castro, is there, she's a commissioner, and in Mark L. 34 Cal 3rd California Supreme Court case, quite some vintage, and the California Constitution, Article 6, Section 22, says, hey, commissioners, yeah, they're commissioners, they're a judicial beast called commissioners, but they may only perform subordinate judicial functions. Well, as lowly as the practice of dependency law may be in the eyes of some, and we know it is not, it is certainly not a subordinate judicial function. So what was the authority, wherein lied the authority for Commissioner Castro to be conducting dependency proceedings? Anybody know from when that authority, or from where is it? Whence? From whence? I don't know where. Anyway, what is the source of that authority of Commissioner Castro to, or Commissioner Marpet, or Commissioner Marilyn Katie Martinez, or Commissioner Losnick, or formerly Commissioner Jackie Lewis? From whence come their authority to conduct dependency proceedings? Anybody know the answer to that question?
They make them judge pro tem.
That is one possibility. How is a judge pro tem? How are you, Tim? Very nice to see you. Tim Bartella. Tim, I'm going to step over here to the side very quickly because I meant to take off this coat, and I'm warm in here. Warm in here.
Guys, if there are not enough seats, it's all being Skyped to the fourth floor.
Here, Marlene.
So Mr. Martinez Mr. Martella has very wisely answered, what is the authority of a commissioner? Well, from whence derives the authority of any of these commissioners? Martinez, Katie Martinez, Losnick, Marpet, Brenda Costa, to conduct dependency court proceedings. And Tim said, hey, they're judge pro tems. Well, how is a temporary judge created? Anybody know how a temporary judge is created? There are two ways. One, written stipulation. Okay, all of you sign that piece of paper agreeing that, frankly, Tim Bartella sit as a judge pro tem today, or Marlene Furz, or Melissa Chaitin. A second way that a judge pro tem is created is pursuant to what's called the tantamount stipulation doctrine. You come into a courtroom, you're the attorney, you know the individual is a commissioner, you don't object, you placidly, maybe not so placidly, you actively participate in the proceedings before the court commissioner. You have, by your voluntary participation, conferred him or her with judge pro tem powers. Okay, so let's try to find another basis. What is the authority of the commissioner? Let's assume no stipulation, tantamount or otherwise. And by the way, there can be no tantamount stipulation in this courthouse to a commissioner sitting as a judge pro tem, nor can there be an express stipulation. Do you know why? Because on the other side of every single blasted 300 petition that's filed is a little notice prepared by county council. And you know what it says? I'll remind you. It says, we're not stipulating that this referee or this commissioner sit as a judge pro tem. We're not doing it. So, Commissioner Marilyn Katie Martinez, referee Loznick, in the past Emma Castro, Mr. Marpet, Ms. Loznick, et cetera, they're not judge pro tems. Give me another basis for the authority of those commissioners to conduct the juvenile court dependency proceedings.
Order the presiding judge.
And what is that? And so Mr. Martella said, order the presiding judge. Close, very close. Annually, the presiding judge, who's going to change, I understand, has issued an assignment order. Every year, beginning of the year, it says, this list of commissioners, Katie Martinez, Marpet, Loznick, Tata, are hereby appointed to sit as juvenile court referees. Aha! What does the Welfare Institutions Code Section 248 says? Guess what? Referees do have authority to conduct proceedings under the juvenile court law, subject to the opportunity for the parties to apply for a rehearing by a judge. That's a constitutional requirement. You know, like in an adult criminal case, you get you're constitutionally entitled to a jury trial. Well, guess what? In a civil case or a quasi-civil case such as this, you are entitled to a trial by a judge. But the legislature has said, and the California Supreme Court has affirmed, hey, referees, that's A-okay. You can have a referee hear a dependency proceeding or a delinquency proceeding. We'll leave out delinquency right now. Dependency proceeding, you know why? Because as long as there's the opportunity for the party to apply for a rehearing. Even if the rehearing is denied, what happens? A transcript of the hearing conducted by the referee is prepared, and a judge of this courthouse must review that transcript, read it, got reviewed by a judge, and if he denies rehearing, it's denied, but at least it has been reviewed by a judge. So bottom line is, every day you walk into a courtroom, you need to identify the beast before whom you appear and his or her authority to conduct the proceedings. That did not happen with Emma Castro. Emma Castro began hearing cases here in juvenile court, dependency cases, as a commissioner. The presiding judge is a very busy man. He overlooked the appointment of Emma Castro to sit as a referee. Trial counsel didn't have a clue that the commissioner was not authorized to conduct the dependency proceedings and didn't object. So I'd like you all to read, I'm going to give you just so you got it down here actually, I write it down so you don't have to write anything down. Anyone who hasn't gotten one of these talking point case sheets of paper, I'm sure Bob Stevenson will hand them out to you, but there's a citation here to the Division 5 unpublished opinion. We are trying to get it published. Don't worry, no slam on you guys. And you know, it's just this is the bottom line. We challenge the authority of Commissioner Castro in a horribly bad facts case. Of course, all of the cases she handled that we're doing this issue in are, you know, really extremely extreme 300D cases. So there's certainly no inclination by the bench, by the reviewing court to reverse, right? But bottom line is Division 5, which is the king of the application of the forfeiture doctrine. That means if trial counsel didn't say anything, then we're not going to hear your argument in the Court of Appeal. Well, trial counsel didn't say anything about Commissioner Castro's 19-day hearing under 300D. So we're not going to reach the issue here of the commissioner's authority to act and we're just affirming the 300, the judgment entered at disposition. Not unexpected, not unexpected. Frankly, it's not unexpected at all. It's fine. I'm fine with it. The good thing about this opinion is it's just a reminder to everybody. By the way, appellate counsel missed it the first time as well. Appellate counsel has gotten very comfortable with writing on the front page of the brief, Commissioner Deborah Losnick, Commissioner Anthony Trendacosta, Commissioner Emma Castro, and not thinking, wait a minute, what the heck is the authority of a commissioner to hear a dependency court proceeding? Okay, so appellate counsel missed it, and we had to file a supplemental brief, request for permission to file a supplemental brief, arguing the lack of authority of the commissioner to conduct the dependency proceeding. So the value in the opinion for you, the reason you should look at it, is that it's just going to tell you about commissioners, referees, judge pro tems, give you the definitions, who the heck they are, okay? It's educational. Just don't ever forget again, because I will write down, I've written down all of your names, all the people that were here, and I said this. Just kidding. Don't worry, I'm not that crazy. I'm not. Don't worry. But anyway, so just remember this. Just take a look at, it's right here, in rate COP, K-A-K. And also, it has as in true Division 5 form, actually they applied the doctrine of estoppel, which is a form of, obstacles to review are forfeiture, invited error, estoppel. I'll give you an idea of invited. Anyway, so the court applied estoppel. You're estopped. Your trial attorney played the game for 19 days, before Commissioner Castro. You're just plain old estopped from making the argument on appeal that Castro did not have the authority to conduct the proceedings. So we lose. We really don't care about that. Really, no terrible injustice was done. Frankly, the parent is a real creepo, and so nobody, nothing terrible has happened. The good part of this is it's very valuable, law. Hey, when do I need to object? What do I need to know? You don't even need to know your client first before you go into the courtroom. Who in the heck is on that bench? Now, I can assure you, after all of this has been going on, with these issues, Judge Nash is now just about, bi-weekly issuing new assignment orders. For example, Steph Padilla, I got an amended assignment order. Steph Padilla, an amended assignment order. Commissioner Castro has now appointed a referee. Is Steph Padilla commissioner? Yes. Yeah. Commissioner Steph Padilla appointed, a referee. I'm getting them rapid fires. Like, oh God, I got it. So, so far, everybody's getting up to speed, but you don't want to get, out of speed.
You want on Terry Trong?
Pardon?
You want on Terry Trong?
And Terry Trong, you sure did. There's one that really bounces around. She lost, as all the referees did in June of 2013 with the budget changes, all the referees went out. Well, Referee Trong went to county counsel's office, and I started getting from county counsel's office, we have our Chinese walls, our screens, and Referee Trong, although she's been a referee, won't touch any other case, blah, blah, blah. And now, I get from Nash, no. We've got now Trong, which is a commissioner, and we're appointing her as a referee. Be very careful, ladies and gentlemen. Every single case that you appear before Trong in, double check if she had ever touched a sibling, this case before. You really got to be very careful to examine conflict with this particular bench officer. And by the way, please get in the habit of referring to commissioners as referees. Okay, they have no authority. Commissioners have no authority to conduct proceedings under the juvenile court law. Their authority to conduct them derives from their appointment, if any, by Judge Nash as a referee. So, Anthony Trendacosta likes to refer to himself, with all due respect, a fine bench officer, as temporary judge Trendacosta. It's in the reporter's transcripts, it's in the minute orders. Where the heck did this come from? Where the heck did this come from? He is not a temporary judge. I'll tell you why he's not a temporary judge. I'll say it again. Anybody want to remind me? Why he can't be a temporary judge? Okay, I'll tell you again. The other thing you're going to do when you walk in the courtroom and you pick up that 300